So we need to talk about a court that just upheld a state's assault weapon ban registration after the Supreme Court's recent denial of multiple assault weapon and magazine ban cases. So let's break down what just happened with this order. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all three major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. And also they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile if you're interested. You can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases which are challenging the state of Illinois and their ban on so-called assault weapons, and then also their magazine bans. Recently, in a Supreme Court order, in the order list, the Supreme Court denied review of the Illinois rifle magazine ban cases. These cases are now back in the hands of the lower court, and we are waiting for merits decisions from the lower court on the constitutionality of the Protect Illinois Communities Act, the PICA, which generally is that ban on assault weapons and magazines, but also the registration process. And we just received a first order in the line of a bunch of orders that we're going to get on this issue. The lower court has now upheld the state's mandatory assault weapon registration, which was included in that law. The court found that the mandatory registration does not implicate the Fifth Amendment's self-incrimination concerns, and therefore, the court there denied the plaintiff's motion for summary judgment, and in fact granted a partial motion for summary judgment in favor of the state of Illinois. This court here did state that he is still set to review the assault weapon ban, the registration process, the magazine ban, and review it in light of the Second Amendment, and ultimately determine if this law in general is a violation of the Second Amendment. So we need to break down not only what happened in this decision, but also talk about what happens now. Now, you might remember that originally in multiple of these cases, a district court judge issued a preliminary injunction that was intended to halt the enforcement of PICA until the court reached a final merits decision. However, the state of Illinois then appealed that injunction up to the 7th Circuit, and on review, a liberal and biased 3-judge panel in the 7th Circuit overruled the granting of that preliminary injunction. And that's what then led to all these cases going to the Supreme Court on an emergency basis for the first time. But like I mentioned, the Supreme Court at the end of their last term denied emergency review in all of the Illinois cases. In that denial, Justice Thomas did make a statement, and he stated that, according to the 7th Circuit, the rifles selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the text of the Second Amendment. The court is rightly wary of taking cases in an interlocutory posture, but I hope we will consider the important issues presented by these petitions after the cases reach final judgment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. He went on to state that the 7th Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. He stated that it is difficult to see how the 7th Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. So although the Supreme Court denied emergency review to all these cases, Justice Thomas did make a statement and said that the Supreme Court is very much interested in this topic. They just want final merits decisions, and then they will potentially review these issues. Now, while the preliminary injunction appeals were going up and they went to the Supreme Court, the lower court judge here, Judge McGlynn, decided ultimately to move all these cases towards that final merits decision that the Supreme Court wanted. One of the final merits issues was a cross motion for summary judgment, which essentially means that both of the parties, the plaintiffs and then also the state of Illinois, filed for motions for summary judgment on various issues. One of those issues was about the mandatory registration process, essentially where there was a deadline for all individuals within the state of Illinois to register their so-called assault weapons with the state. And if they did not do that, or they did not modify those weapons, well, then they could potentially be in possession of an illegal assault weapon and then open to criminal penalties. The Langley plaintiffs argued in their motion for summary judgment that the mandatory assault weapon registration should in fact be struck down by the court here because it's a violation of the Fifth Amendment. The plaintiffs argued that the registration process would result in self-incrimination, which is a violation of the Fifth Amendment. Now, in response, the state of Illinois argued that the Fifth Amendment, of course, was not implicated by the registration here and that the judge here should essentially just dismiss those claims. Well, we now received an order from the court here, and the court decided to side with the state of Illinois on this narrow issue about whether or not the Fifth Amendment makes this registration process unconstitutional or not. The state argued that self-incrimination is not implicated under the Fifth Amendment because registering is not the only option. So one of the first arguments made by the state of Illinois is that the Fifth Amendment here in the criminal self-incrimination is not implicated because there are other options available to residents in the state of Illinois. They can destroy them, move them out of state, sell them off. And so the only option is not just simply to register. So the argument that they have to self-register or that it's a mandatory self-registration, which opens people up to criminal liability, that is not the only option. So that's how they're trying to wiggle around the Fifth Amendment implications. The state also argues that there was no evidence presented that the state of Illinois here would actually use the registration information criminally against individuals. Specifically, also, there was an issue about whether the plaintiffs here have standing to even bring that claim because there is no evidence that they have registered these, items, that they have an affidavit, or that the state of Illinois is using that information currently against these plaintiffs. And because of that, the judge here concluded that the Fifth Amendment is not implicated with the registration process. The judge stated that PICA does not impose any penalties whatsoever for failure to submit an endorsement affidavit alone. Criminal penalties arise from possession of a prohibited weapon or item and failure to submit a registration affidavit. They also say the plaintiffs do not have standing to bring the Fifth Amendment claim because essentially they have not indicated that any of the named plaintiffs have filed endorsement affidavits or whether any of them have retained possession of weapons prescribed by PICA after January 1st, 2024. So they're saying that's kind of the standing issue. There are no plaintiffs, according to the court, that are making a claim that they did not file an affidavit, that they did not register, and that they're currently in possession of what would be an illegal assault weapon, and that any actions have been taken against them. So again, the court here is kind of trying to wiggle out of the Fifth Amendment argument by saying, well, standing is not met. However, even though the judge found that the registration process could not be struck down under the Fifth Amendment, he did make it very clear in this order that that does not mean that the upcoming review on the merits of all of these issues based on the Second Amendment will not lead to a different decision and ultimately it being struck down based on the Second Amendment. He stated that at this stage, the court holds that the endorsement affidavit process provides means for Illinois FOID card holders to continue to keep weapons they are no longer able to purchase in Illinois. The court will adjudicate the Second Amendment claims in its final review on the merits, during which the registration requirement will be assessed in accordance with the Second Amendment guidance set forth in Beavis and then also Bruin. In summary, the Langley plaintiffs' Fifth Amendment arguments are legally deficient and do not hold water with established case law. Because of this, the Langley plaintiffs' motion must be dismissed and Director Kelly's cross motion must be granted. And based on that, the judge here denied the plaintiff's request to find that the registration process was a violation of the Fifth Amendment. However, again, keep in mind, the registration process is still being challenged under the Second Amendment under Bruin in that Supreme Court precedent, and the judge is set to decide on that issue as well. Currently, I believe there's a bench trial set for September 16th where that issue will be raised. A general challenge based on the Second Amendment will be challenging not just the affidavit process and the registration process, but just generally the constitutionality of PICA and the ban on assault weapons and magazines and all of that. So there is still a Second Amendment pure challenge pending. This was a decision just on the Fifth Amendment. But ultimately, the court did find that the Fifth Amendment does not void this registration process, and so they ruled in favor of the state of Illinois. So if anything else develops, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.